The House Criminal Justice Committee will come to order. Would the clerk please take attendance?
Chair Hope.
Here.
Representatives Andrews.
Here.
Carter.
Present.
Breen.
Present.
Young.
Here.
Arbit. Dievendorf.
Here.
Cerniglu. Cerniglu.
Here.
Filler.
Yes.
Mueller.
Here.
Bazat.
Here.
Harris.
Here.
De Gaulle.
Here.
Madam Chair, you have 12 members present. You do have a quorum.
Thank you. Representative Andrews moves to adopt the minutes from the March 21st meeting. Without objection, the minutes are adopted. And we will now turn to a presentation from Jessica Zimbelman of the Criminal Defense Attorneys of Michigan. go ahead and get started. Whenever you're ready, make sure to push the button.
There you go.
Just use arrows.
Yep.
Good morning, everybody. My name is Jessica Zimbelman. I'm a managing attorney at the State Appellate Defender Office, and I'm co-chair of the Criminal Defense Attorneys of Michigan Rules and Law Committee. And I just have to say that my first professional job was 20 years ago as a legislative aide. So it is really good to be back in the Hob in this capacity this morning. It's good to see you all. Thank you for having me. I wanted to start off today by talking about how the provision of a criminal defense attorney is provided for in both the Michigan Constitution and under the Sixth Amendment of the federal Constitution. Our jobs and what we do for our clients is explicitly guaranteed in both our state and federal constitutions. And that's important. I think I remember hearing at one time that we are the only profession or job guaranteed in the federal Constitution. And I'm just going to run through some of CDAM's priorities or things that we're looking at in this legislative session. Some are carried over from last term, and some are new initiatives this term. And I welcome the court's question, because that's what I'm used to saying. I welcome your questions at any time. Starting off, kind of the first broad category is youth justice. And one of our priorities is the elimination of life without parole sentences for those 18 and under. I know a lot of people on this committee are co-sponsors of the bills that have been introduced in the House that would ban life without parole sentences for those 18 and under. And that's under both the federal and Michigan constitutions and Michigan case law that extended the holdings of Miller to those 18 and under. The expansion of MIDC services to young people. A lot of these next recommendations come out of the Task Force on Juvenile Justice Reforms, and some of these initiatives I'm mentioning are provided for in the appropriations process. But expanding the Michigan Indigent Defense Commission to cover the provision of representation to young people is an important priority and reform to our system. That also includes expanding the State Appellate Defender Office to include youth adjudication appeals. There are very few young people who appeal their adjudications as young people, and that can really affect, the lack of an appeal can really affect one's future, as any adjudication will. But not having the opportunity to even challenge that or appeal that is important, and the provision of a lawyer, a constitutionally guaranteed lawyer, is important. There are a host of other recommendations in the Task Force on Juvenile Justice Reform. As I mentioned, some are provided for in the appropriations process, such as creating a Juvenile Justice Services Division within SCAO, the Michigan Child Care Fund to change the funding mechanism where it would be 75% state funds instead of 50% state funds, a Best Practices Commission for community-based services. Some of those are provided for in the appropriations process. I wanted to highlight a couple other recommendations that came from the task force, such as eliminating non-restitution fees and costs for young people, creating a residential advisory committee, and creating reforms to detention. I'm sure many of the committee members are aware of the news out of a couple facilities in Wayne County where there were some abuses of young people and deplorable living conditions, and certainly some reforms to the process, and creating a residential advisory committee might help provide that necessary oversight for places our young people are being put. Another idea, of course, is diversion for young people to keep them out of the system, and then juvenile-specific probation standards for those young people who are put on probation.
Can I interrupt you right there? I wonder, does CDAM have a position on re-incarcerating youth for status offenses?
I think that we don't have a formal position, but I can think that our attorneys and our organization over relies on incarceration for our kids, that there should be other options, especially for a status offense or misdemeanors. We've got to have other options than incarcerating children. The next bucket I want to talk about is excessive sentencing reform. The first thing I want to talk about is a fix to a decision called Gardner. We call it colloquially the Gardner fix. And this is a 2008 decision from the Michigan Supreme Court where the court said that for a habitual offender notice, multiple crimes committed in a single transaction count as separate convictions. So say somebody does one thing, or we might say there's one bad night, and multiple offenses are charged and the person is convicted of multiple things. All of those, even though it comes from one transaction, can be used to habitualize somebody, which can increase their sentencing guidelines range dramatically. So you could become a habitual offender fourth, which kind of can max you out on the guidelines for one bad night. So that's a high priority and has been of CDAM for years, is to try and fix the habitual offender laws, and as a result of that opinion, to require that to habitualize somebody, it should be separate transactions. Mitigating offense variables. Our sentencing guidelines right now, there are 20 offense variables. All of them are aggravating. So based on a variety of factors, psychological harm, physical injury, use of a weapon, those all add points, which again increases somebody's potential sentencing guidelines range. In the federal system, there are mitigating variables where you can have points subtracted based on cooperating, for example. There was a lot of discussion about incorporating mitigating offense variables into Michigan's guideline system, and that is a long overdue reform that would also put us in line with federal sentencing practice. And the Sentencing Commission. I know you're going to hear a lot about this later today, but CDAM strongly supports the creation of a sentencing commission, and that commission could then, of course, look at things like the creation of mitigating variables. The next bucket I want to talk briefly about are post-conviction impacts for the people we represent. There was discussion last term, I think there was some legislation introduced to eliminate excessive costs and fees for families with incarcerated loved ones. And primarily I'm talking about the phones here. And we know that staying in contact with somebody's friends, family, and loved ones is one of the most promising ways to ensure somebody can come out of prison and come home successfully and not go back. But the costs that we impose on friends and family of those people who are incarcerated can prohibit that connection that is needed for rehabilitation. And then, of course, you'll hear about this later today too, is the importance of having identification documents for people who parole. And these bills, there's been testimony about them. I know that, and some press, but really these bills codify existing practice. And it's important when people come home that they have the documents they need to get started right off the bat. Get a job, get housing, get a bank account. Those are things that we can sometimes take for granted, but it's really important for people to have the right documentation coming home. And then the last bucket I want to talk about is some system reform issues. Bail reform. This is a big one. This is a big topic, and CDAM is happy to meet with you individually or in smaller doses to talk about this big issue. But the premise behind bail reform is that for some people, it could be $100 that they are required to post for bond or bail. But that $100 is problematic and can affect somebody's job, their home, if you can't post that money. So the idea is behind this reform is to give poor people the same access to justice as people with money. Because if you're accused of a crime and you are fortunate enough to have money to post a bond, you're home. You're with your family. You're working your job. You're living in your house or your apartment. There's no disruption there. But for a poor person, that is very different. And that those even $100 bond can really change the course of somebody's life. So that's the kind of big picture issue we're talking about when we talk about bail reform, and it's essential, and it's an essential system reform. Jury selection reform and eliminating one-person grand juries. This also was discussed last session, and we're excited to have those discussions continue this summer. It involves how we select our jurors, whether that's court-initiated questions, what type of questions we can ask, whether there's a felony bar to service, and then, of course, whether one-person grand jury should be eliminated after the Michigan Supreme Court decisions last summer. The Task Force on Forensic Science, they issued some preliminary recommendations in December, I believe, and some of those included the creation of a forensic science statewide body, the need for accredited labs, the need to register expert witnesses, independence of forensic scientists within law enforcement agencies, and possibly some amendments that will be needed to the Michigan Rules of Evidence or our standard jury instructions. That's outside maybe the realm of the legislature here, but there are a lot of policy recommendations from the Forensic Science Task Force that would also improve the fairness of our system when we're using science at a trial. Diversion and restorative justice, these are big concepts too. There's a lot of different ways you can go about diversion or restorative justice, but it's essentially different ways to achieve the same goal, which is outcomes that are fair to victims and also not disproportionately punitive. We want to come to those outcomes that are fair to all parties involved. And lastly, I'll talk about the very exciting topic of data access. This is important for us in the system, and I know there were efforts last term to work with SCAO on justice data reporting and a unified system of how to collect the data from our trial courts. And on a last pitch, especially during the pandemic, a lot of counties went to e-filing. And you can pull up in various counties the register of actions and see when pleadings have been filed. Now, those are public documents, but you can't click on a link to access that document. And that would be a reform in efficiency that would help practitioners and help us represent our clients without having to wait to be served by mail or to have to email a clerk or email the prosecutor. If we could just click on a link and get publicly filed documents, that would be a exciting reform for us as practitioners. So that's all I have for you today. I'm happy to take any questions, and I know that we'll be providing input on some of these bills when they come up for testimony.
Thank you very much for that presentation. I know that you have a commitment actually in court, right? Right after this, so we won't detain you. I assume you'll be available to answer questions offline, but we do have a question from Representative Arbit.
Thank you, Madam Chair, and thank you so much for coming today to testify. I wanted to just ask you real briefly about, the mitigating sentencing variables. Is there a way to do that, to implement that's system-wide without sort of opening up every criminal statute that we have? What is the most effective, way that we can implement that at a larger scale here in Michigan?
Sure. I think you wouldn't have to open up every criminal statute. You would add new statutes. So each of the 20 offense variables has its own MCL code. And so what I see happening is you add MCL codes for the mitigating variables.
So what you're not really referring to is, in each statute that you have, criminally, that says, he gets to be charged, because even you go in, aggravating factors to, transcend something from a misdemeanor to a felony, that at that point too, it's, sort of gets to the same problem.
Correct. And that's not what I'm talking about. I'm talking specifically about the creation of variables that are taken into account at every felony sentencing in Michigan. So it would be adding new MCL codes.
Got it. Thank you.
Yep.
Representative Cerniglu.
Thank you. Quick comment and then question. Just thank you for your work on CDM. About 20 years ago, I went to one of your trial trainings, and it was really like the best training opportunity I ever did as a young
So
attorney.
good to hear.
Thank you. And regarding the juvenile justice piece, I'm a little outdated in my knowledge of what's currently happening with our juvenile justice system. Is it moving away from like the community-based trying to keep people in their homes model right now? And are we trying to move back towards that, or where does that stand right now?
Admittedly, I am not the expert on this, but my understanding from the Juvenile Justice Task Force recommendations is we are trying to get back to the community-based system and to keep kids in their home, out of detention, whatever way that looks like, that we are over incarcerating children. And I can provide some more information for you too.
Representative Mueller will have the last question.
Thank you, Madam Chair. Regarding the habitual offender, I agree with you to some extent on this. However, we also have to make sure, again, because I'm a big victim advocate, that when you have jurisdictional lines like where I used to work, you have Tyrone Township and Livingston County, Oakland County is right there, Genesee County is right there. Someone goes around and breaks into 30 cars in 3 different counties. To me, that's 3 different crimes because you stopped one crime and did another. There's a difference between getting into a chase with a bank robber. He flees, you get into a chase, he hits a car, he rolls, he runs from the police, he gets an R&O, he gets an injury. Yeah, that's one incident because it's all tied together, and I agree to that point. But if you're going to do this, I would suggest, having, if there's a change in venue, that change of venue also allows for another crime to be tacked on. Not, because what are these jurisdictions going to do when they try to do collect victim compensation where someone had cars broken into in one subdivision across the county line, but that gets put away and they don't have really a good remedy to do it. So just keep that in mind when you're going down that road.
I appreciate that. Thank you, Representative.
Thank you, Ms. Zimbelman. Sorry.
Thank you.
I'm still working on my coffee here, so we appreciate you and appreciate you making yourself available
Yes.
for questions.
Thank you for the time.
Good luck today.
Thank you.
We will go at ease at the call of the chair. I call the committee back to order. Our next order of business is to vote on substitutes for House Bills 4191, 4192, 4193, and 4194. The committee members will recall that we took testimony on these bills way back before break on March 21st. Okay, we do have a couple of cards to read in. Peter Rourke from the Michigan League for Public Policy supports the bills, does not wish to speak. Joe Haveman from the Hope Network, no connection there. Supports 4191, 4192, and 4193, does not wish to speak. And then Judy Karangeff, from the League of Women Voters, supports the bills, does not wish to speak. I'll take a motion to adopt the H1 substitute to 4191. Representative Devendorf moves. Madam Clerk, will you please call the roll, or the vote?
Chair Hope,
Yes.
Representatives Andrews,
Yes.
Carter,
Yes.
Breen. Aye. Young.
Yes.
Arbit,
Aye.
Devendorf,
Yes.
Cerniglu,
Yes.
Filler,
Yes.
Mueller,
Yes.
Bazat,
Yes.
Harris,
Yes.
Begol.
Yes.
Madam Chair, you have 13 yeas, 0 nays, 0 pass. The substitute to House Bill 4191 is adopted.
Thank you. I will now take a motion to adopt the H1 substitute for HB 4192. Would you please call the vote? Oh, I messed up. I'm sorry. I will now take a motion to report 4191 with recommendation as substitute H1. Would you please call the vote, Madam Clerk? So moved by Representative Breen. This is only the second bill we've moved out of committee, so I beg your indulgence here.
To report House Bill 4191 with recommendation as substitute H1, Chair Hope.
Yes.
Representatives Andrews,
Yes.
Carter,
Yes.
Breen. Aye. Young,
Yes.
Arbit,
Aye.
Devendorf,
Yes.
Cerniglu,
Yes.
Filler,
Pass.
Mueller,
Pass.
Bazat,
Pass.
Harris,
Pass.
Begol.
Pass.
Madam Chair, you have 8 yeas, 0 nays, 5 pass. House Bill 4191 is reported with recommendation as substitute H1.
Thank you. I'll now take a motion to to adopt this H1 substitute. I'm doing a terrible job this morning. Apparently, I haven't paid attention in any of my committees over the last 5 years. I will now take a motion to adopt the H1 substitute to HB 4192. Representative Breen moves. Would the clerk please call the roll?
To adopt the substitute H1, Chair Hope,
Yes.
Representatives Andrews,
Yes.
Carter,
Yes.
Breen. Aye. Young,
Yes.
Arbit,
Aye.
Devendorf,
Yes.
Cerniglu,
Yes.
Filler,
Yes.
Mueller,
Yes.
Bazat,
Yes.
Harris,
Yes.
Begol.
Yes.
Madam Chair, you have 13 yeas, 0 nays, 0 pass. The substitute is adopted.
Thank you. I will now take a motion to report HB 4192 with recommendation as substitute H1. Madam Clerk, will you please call the vote? Moved by Representative Arbit.
Chair Hope,
Yes.
Representatives Andrews,
Yes.
Carter,
Yes.
Breen. Aye. Young,
Yes.
Arbit,
Aye.
Devendorf,
Yes.
Cerniglu,
Yes.
Filler,
Pass.
Mueller,
Pass.
Bazat,
Yes.
Harris,
Pass.
Begol.
Pass.
Madam Chair, you have 8 yeas, 0 nays, 5 pass. House Bill 4192 is reported with recommendation as substitute H1.
Thank you. I will now take a motion to adopt the H1 substitute to HB 4193. Representative Devendorf?
Chair Hope,
Yes.
Representatives Andrews,
Yes.
Carter,
Yes.
Breen. Aye. Young,
Yes.
Arbit,
Aye.
Devendorf,
Yes.
Cerniglu,
Yes.
Filler,
Yes.
Mueller,
Yes.
Bazat,
Yes.
Harris,
Yes.
Begol.
Yes.
Madam Chair, you have 13 yeas, 0 nays, 0 pass. Substitute H1 to House Bill 4193 is adopted.
Thank you. I will now take a motion to report HB 4193 with recommendation as substitute H1. Representative Breen moves. Madam Clerk, would you please call the vote?
Chair Hope,
Yes.
Representatives Andrews,
Yes.
Carter,
Yes.
Breen. Aye. Young,
Yes.
Arbit,
Aye.
Devendorf,
Yes.
Cerniglu,
Yes.
Filler,
Pass.
Mueller,
Pass.
Bazat,
Pass.
Harris,
Pass.
Begol.
Pass.
Madam Chair, you have 8 yeas, 0 nays, 5 pass. House Bill 4193 is reported with recommendation as substitute H1.
Thank you. I'll now take a motion to adopt the H1 substitute to HB 4194. Representative Carter moves. Madam Clerk, would you please call the vote? Yes.
Representatives Andrews,
Yes.
Carter,
Yes.
Breen. Aye. Young,
Yes.
Arbit,
Aye.
Devendorf,
Yes.
Cerniglu,
Yes.
Filler,
Yes.
Mueller,
Yes.
Bazat,
Yes.
Harris,
Yes.
Bagol.
Yes.
Madam Chair, you have 13 yeas, 0 nays, 0 pass. The substitute is adopted.
Thank you. And now I'll take a motion to report HB 4194 with recommendation as substitute H1. Moved by Representative Breen. Madam Clerk, would you please call the vote?
Chair Hope,
Yes.
Representatives Andrews,
Yes.
Carter,
Yes.
Breen,
Aye.
Young,
Yes.
Arbit,
Aye.
Devendorf,
Yes.
Cerniglu,
Yes.
Filler,
Pass.
Mueller,
Pass.
Bazat,
Yes.
Harris,
Pass.
Bagol.
Pass.
Madam Chair, you have 8 yeas, 0 nays, 5 pass. House Bill 4194 is reported with recommendation as substitute H1.
Thank you. We now need a motion to refer HB 4046 to the Judiciary Committee. Representative Filler moves. Madam Clerk, would you please call the vote?
To refer House Bill 4046 to the Committee on Judiciary, Chair Hope,
Yes.
Representatives Andrews,
Yes.
Carter,
Yes.
Breen,
Yes.
Young,
Yes.
Arbit,
Aye.
Devendorf,
Yes.
Cerniglu,
Yes.
Filler,
Yes.
Mueller,
Yes.
Bazat,
Yes.
Harris,
Yes.
Bagol.
Yes.
Madam Chair, you have 13 yeas, 0 nays, 0 pass. House Bill 4046 is referred to the Committee on Judiciary.
Thank you. And now we will hear testimony on House Bill 4173. Representative Ayash, Representative Meerman, go ahead and get started whenever you're ready.
Thank you, Chair. If it's okay with you, I'd like to invite up Joe and Barb. Oh, they got here.
Absolutely. Would you mind introducing them? Or having them introduce themselves?
Yeah, go ahead.
Joe Havman from Hope Network.
Barbara Levine. I have a history of involvement with the Criminal Justice Policy Commission. So,
And there's no affiliation with you, Madam Chair, so. Okay, good morning, colleagues. Thank you all for taking up this bill, House Bill 4173. I just wanted to, before I start talking about the bill, I just wanted to let folks know that we will be working on this bill and that it will become two bills. So some mitosis will be happening with the legislation, which is why Representative Meerman is here, because this is an issue that we're both passionate about and we've worked on together. So, in summary, House Bill 4173 will create a 19-member sentencing commission, and the task is going to be lofty, which is why we need experts at the table to address some of the issues regarding collecting, analyzing, and disseminating information on state and local sentencing and release policies. So, the commission will have 5 main principal focuses. Number one, researching the effectiveness of guidelines as it provides for public safety, reducing sentencing disparities beyond offense characteristics, and ensuring proportionality to the seriousness of the offense. It will also cooperate with MDOC, the Michigan Department of Corrections, to make projections regarding population capacity in state prisons, the impact of our sentencing guidelines, and the effectiveness of the efforts to reduce recidivism. It will cooperate with the state court administrator to collect data on the effect of sentencing guidelines on the caseload, docket flow, and case backlog of trial and appellate courts. It'll submit annual reports to the Michigan legislature on the implementation of legislative policies affecting the CJ system. And it will submit policy recommendations affecting sentencing and the use and length of incarceration on the legislature for the legislature's consideration. And I want to emphasize what the commission will not do. The commission will not make any recommendations that will retroactively affect existing sentences that have already been imposed. This is simply for future recommendations for sentences. and it will also not make recommendations affecting behavioral or programming credits, for example, like the good time credits. So that's a quick summary of what the bill does, and I will pass it along, if it's okay with you, Madam Chair, for any questions.
We do have a question from Representative Filler.
Sure. So in Michigan, we've had the Pew Task Force. We have MDOC, which has lowered recidivism down to lowest rate of prisoners since the 80s. We have treatment courts, which are remarkably effective and popular. I guess my question is, why would we need another layer of bureaucracy telling us what needs to happen in the justice system?
Well, thank you for the question, Representative. We haven't had a sentencing commission in over 30 years, and nearly every other state has one. And although that's not a reason to do it, just because nearly every other state has one, I think it's important that we recognize the gravity of what putting someone in prison means. It's an expensive, serious undertaking by the state, and it's something that we should have experts look at. You know, I'm certainly not somebody that can give you the best recommendations in terms of all the technicalities and what would and wouldn't make sense for making some of these cases. But if you look at sort of what's happened in the last 30 years, for example, just to give you a quick example around the way we view drug crimes and folks who have experienced mental health episodes, you know, one would argue that we probably have to reassess how we're addressing some of those issues. And if you look at something like domestic violence, you know, it was not something that 30 years ago, I think the punishment fit the level of severity of that crime. So quite frankly, you know, this is the best way to try to simply allow the legislature to lean on the experts. You lean on victim advocates, you lean on folks in the incarceral system, and you look at folks who deal with these situations every single day. You know, this 19-person commission would help work through all of those things from the experts that are dealing with this all the time.
And a quick follow-up, you don't believe that that's being done right now?
No. Not in the centralized way that we
not by MSP, not by corrections.
So this would centralize it and
Not
bring
by
all.
SCAO.
This would bring all stakeholders to have expert discussions, to do research, and just simply lay out the information that's necessary for the legislature to then look at and say, is this something that would make sense for us to review? Is this something that would make sense for us to re-examine? You know, this really just allows the mechanism to bring all stakeholders to the table in a formal setting to really address it and lean on the experts and lean on the research to figure this out. I think, to your point, Representative, a lot of this is happening in fragmented pieces, and allowing us to be able to bring everybody together would provide for, I think, a more efficient way to address some of the sentencing guidelines in the state.
We do have more questions, but before we move on, I did want to mention, and my apologies, Carl Reynolds from the from the Council of State Governments Justice Center. He is the senior legal and policy advisor, and he is on Zoom. Representative Young.
Thank you. Thank you for your testimony. Thank you for the work on this. I just had a couple of questions as it relates to how the members are being selected. What I found throughout the bill is it says from a list of 3 names submitted by some entity or organization. But then there are a couple of places where it doesn't do that. One individual who was previously incarcerated and one individual who represents Community Correction Agency. So I'm just curious, how are these single one individuals being selected? Because it's clear how the others are being selected, and why don't we have an option of 3? And what comes to mind is, because we know in this space there are some people who people call on all the time, but there are also so many other people that are doing really good work. I'm not throwing my brother under the bus, but Darrell Woods is a guy who you see every single time. And he has enough stuff on his plate, and I would hope he wouldn't just be that one individual because he's the one person we see every single time. So I'm curious how we're going to select in those 2 different instances, because they're different from the others.
Yeah, thank you, Rep. Young. So if you look, it starts with an individual appointed by a list of 3 names submitted by the director of the department, and then it goes on to list previously incarcerated criminologists, community corrections. So there's still 3 names, but it comes from the Michigan Department of Corrections.
Which version do you have?
Okay. Wrong version.
I'm sorry, Representative, what page were you referring to? My apologies. Okay.
Are selected, if we just start at the B line, 2 individuals, or, let me see here, a D.
D, okay.
Individual who, and when you go down, you have an option of selecting from 3 individuals, 3 different people, until you get to where it says, but there's one individual who was previously incarcerated.
Right.
And there's no option, there's just one person, and so I'm just curious to know, why did you change when there were 3 previous, and every other example? until we
Yeah,
got
yeah.
there, until we got to the other?
That's a good question. It just we identified certain organizations that have sort of an overarching group. So, for example, with the prosecuting attorneys, we have PAM, and as it relates to a formerly incarcerated individual, there is not one central organization that we could refer to that would, I think, justify selecting one specific organization over the other. So in that case, this would be a decision that the governor would be able to select an individual. Does that help clarify that point? Because I can't, I mean, it's hard to identify. There's plenty, to your point, there's Safe and Just, there's Michigan Liberation, there's several organizations that deal with a lot of formerly incarcerated individuals. To try to pinpoint one, I think would be difficult. Whereas, for example, the sheriffs, I mean, there's the Michigan Sheriff's Association, right? So there's that one central group that we can look to and then say that it would be, I think, a fair assessment on their recommendation, given that they're a centralized organization with really widespread membership.
I get that. I guess I'm still looking at it in the sense of some of those groups that you mentioned. That's what she's gonna have to go to. Whoever the governor is gonna have to go to some of these groups
Right.
and get those names. They're not gonna come out of hat. So that was the only thing that just kind of stuck out
Yeah,
to me.
no, I think that's a fair point. And if it's something that, got it. Thank you. Of course.
We do have some more questions, but I'll ask that members hold their questions. We will have an opportunity after these other folks testify to take questions, if you don't mind. And you may proceed at your pleasure.
I will just take a minute to introduce myself again and give a little history. I served in the legislature until 2014. This was the last bill package that I put forward in lame duck of the bill package. 2 bills passed. This was one of them. There was what I call kind of a poison pill in that bill that was a compromise, and that was to put a sunset on the commission, which I think was the reason that it failed. The members, some members that didn't want it, others that were opposed to it, just basically wrote out the clock on the commission, and it disappeared again. I just completely agree with Representative Anish. Boy, there's a blast from the past. Sorry. In moving this forward, it is so important, I believe, that when you exercise this kind of authority, this kind of power as a government to take away someone's freedom, that the experts should be weighing in. And Representative Filler, I respect what you're saying. Some good things have happened in the past 10 years. And we have seen a change in attitude on how we take away those freedoms and where it's appropriate. I just firmly believe that should be carved in stone, that we review it on a regular basis, and that the experts on both sides of this conversation be around a table to look at this. Frankly, I did not feel when I served up there that I had the expertise. Now, I see a lot of law enforcement and lawyers that maybe you're far better at it than I was, but I didn't feel I had the expertise to impose a sentencing guideline on someone for a crime And so often, we would see legislators come in, and it would be the easy bill, frankly, to get a PA on, is impose a sentencing guideline. Or if a constituent group or a constituent back home came and said, hey, this happened to me, therefore I want my pound of flesh, we would come up with a new sentencing and basically make something more illegal than it was already. And I think that's a wrong way to look at our criminal justice system. So thank you for bringing this up, Representative, and thank you, committee, for taking it up.
Good morning. My name is, again, Barbara Levine, and I was a member of the work group that Rep. Havemann put together to pass the Criminal Justice Policy Commission bill back in 2014, and then I was a member of that commission from 2015 through 2019 throughout its existence. So that's sort of what I bring to this. Before I make a few very brief remarks, I want to respond in addition to Representative Filler's question. He rightly pointed out a lot of things that are going on in the criminal justice system, a lot of them very positive. But the sentencing guidelines are also going on. This is about the guidelines. And the guidelines they've had ad hoc amendments by the legislature here and there over the years, but they haven't been systematically reviewed. And those set they set the bottom line when sentencing is going on. So the fact that the department has managed to reduce the population, that there may have been some positive changes in parole, that there may be changes in community corrections or specialty courts, those are all good, important things. But the guidelines are a thing in themselves, and they need to be reviewed to see the extent to which they're even being complied with, and what the effectiveness of the guidelines are. So that's what this is largely focused on. And the points I really want to make are three simple ones. First, an assessment of the guidelines is long overdue. A broadly representative commission is the best body to perform that assessment. And this bill really should be an easy call because it has no immediate impact, and it commits the legislature to no particular outcome. It merely establishes a process that could have important consequences down the road. So to each point very briefly, as to the need to assess the guidelines, when the current sentencing guidelines were developed by the original Sentencing Commission in the late 1990s, they were inevitably based on assumptions and educated guesses about what their impact would be. No one could know for sure at the outset how judges would apply the guidelines, what sentences would actually result, what the impact on correctional resources would be, or how a relevant body of law would develop on appeal. It was envisioned always, it was envisioned at the time, that that commission would stay in business, it would monitor the implementation of the guidelines. It would collect and analyze data and determine whether the underlying assumptions on which the guidelines were built had actually proven to be accurate. It would assess whether the legislature's goals in enacting the guidelines were being met and whether there were unintended consequences to be addressed. If needed, the commission would recommend modifications to the legislature. All that's really explicit in the enabling legislation for the original Guidelines Commission. But none of this happened. Once the guidelines were enacted, the original commission never met again. It was initially defunded, and then its enabling legislation was repealed. As a result, we have gone for 25 years without any systematic analysis of how effectively the guidelines are serving their intended purpose. We came close. In 2014, Rep. Havemann convened a work group that resulted in the Criminal Justice Policy Commission. That work group was very diverse. It included stakeholders who rarely saw eye to eye on anything. But the need to assess the guidelines was so apparent that the group's support for establishing the CJPC was unanimous. And the enabling legislation, as I recall, passed with bipartisan support. Unfortunately, for a whole variety of reasons, the CJPC didn't complete its task before it reached its sunset. Notably, every stakeholder represented on the commission supported extending the sunset, but that didn't happen either. So here we are with the work still remaining to be done. Second, a new commission is still what's needed. Developing sentencing guidelines is a complex process. You're talking about deciding what a reasonable presumptive sentence would be for every crime in the penal code, and then deciding when and to what extent judges can make sentences longer or shorter than that presumption, depending on the facts of the individual case. There's a lot of very detailed work to be done that requires familiarity with how the guidelines work, thoughtful consideration of the various policy issues laid out in the legislation, and access to data about such matters as current average sentences, recidivism rates, and the extent to which judges follow the guidelines recommendations or depart from them. It takes staff with the capacity to do the statistical analyses of the data, to model the outcomes of potential changes, and to research best practices from other jurisdictions. This is not work that can be done effectively by a legislative committee. It takes time, and that's why, as you will hear from Mr. Reynolds, other sentencing guideline jurisdictions generally have commissions, staffed commissions that sit continuously to do the work. But in Michigan, ultimately, the commission's product goes to you. You can adopt it, amend it, or send it back for more work. The commission is meant to have influence as the result of its effort, integrity, expertise, and broad stakeholder representation. But its only power is the power to persuade you to agree with it. Finally, this bill really should be, I think, an easy call. It doesn't change the current guidelines in any way. It merely sets up a process for considering whether to change them. You're not committing to any particular outcome. There's no way to know now where the evidence will lead and what a commission might ultimately recommend. But what we do know is that sentencing involves the most critical functions of government: protecting public safety, being fair and cautious in restricting individual liberty, and spending billions of taxpayer dollars annually. Now that we have decades worth of data available to us, it is time to determine just how well these functions are being performed and whether there are ways to do better.
Thank you. Before we turn to Mr. Reynolds, I did want to give the bill sponsors an opportunity to talk about the makeup of the commission and how it may ultimately be different than the bill we have before us right now.
Yeah, and I want to apologize to Representative Meerman. He was looking at the draft that would have had those changes. So we've had conversations with law enforcement and victim advocates, and there's going to be a change from what you're seeing now. There will be the removal of one person, the nomination for the Michigan Association of Counties, and a reduction of criminologists. I'm fasting, so forgive me. From 2 to 1, and then replacing those two individuals will be a circuit court judge and a police chief. So we're adding 2 victim advocates and changing up the makeup from there. So other than that, everything else you see in the bill will be as is. But I would defer to you, Madam Chair, in terms of when the substitute would be adopted, and we'll give you ample time to obviously look through that. So again, I want to apologize because Rep. Meerman was sort of ahead of the curve there, and which is why the lines were a little bit off. Representative Young.
Thank you. And I still have your names down if you had a question, but we will turn to Mr. Reynolds on Zoom.
Thank you, Madam Chair. Members, my name is Carl Reynolds. I'm with the Council of State Government's Justice Center. I'm the Senior Legal and Policy Advisor. I'm coming to you from Austin, Texas, from my home office, and I really appreciate the opportunity to testify virtually. The Council of State Government's Justice Center is a national nonprofit, nonpartisan organization that combines the power of a membership association with policy and research expertise to develop strategies that increase public safety and strengthen communities. I wanted to talk about just 3 points that are relevant to this bill. One is about other states. One is about the history of sentencing, a kind of unique, notable history of sentencing in Michigan. And then finally, a little bit about the project that I led in 2013 and 2014, which was a very deep dive into the workings of your sentencing system that yielded all kinds of interesting analysis and included the recommendation that Michigan really needs to have a sentencing commission to carry that kind of work forward. So backing up to other states, 25 states or more have a sentencing commission. There are 22 states that currently participate in the National Association of Sentencing Commissions. And by the way, I'm on the executive committee of the NASC, the National Association, deeply involved in the work of sentencing commissions around the country. There are at least 3 more states that I'm aware of that have serious sentencing studies underway. California, Colorado, and New Jersey are all involved in some pretty interesting work on sentencing without having the formal label of a sentencing commission. And every state that has actual sentencing guidelines, except Michigan, has a functioning commission. As a resource, I would really point you to the Robina Institute. They have a wealth of information, including profiles of all the sentencing guidelines states, including Michigan. And I will send, I'm going to make reference to a couple of things that have web links, and I'll send those to the clerk so that members can see those. And then finally, with regard to other states, I would urge you to think about looking at Pennsylvania as a really interesting sort of example of a very strong sentencing commission staff housed in the legislative branch, as this proposal would do, and with remarkable university partnerships that really strengthen the work and the research that the Sentencing Commission does. Pennsylvania is kind of at the opposite end of the spectrum from Michigan in that they have a well-staffed, highly functioning sentencing commission that's been around for decades. And so as an aspirational model, I'm not saying you should try to get to Pennsylvania right away. It is at the opposite end of the spectrum from a state with guidelines and no commission, but they do remarkable work, and in a state that is in some ways quite comparable to Michigan in terms of population and urban-rural dynamics and so forth. Second, I want to say a little bit about Michigan's notable sentencing history that goes all the way back to the beginning of the last century. In the early 1900s, your Constitution was amended to allow for indeterminate sentencing. It has the phrase indeterminate sentencing in the Constitution, which may be unique. And a law was passed right after that. It's still on the books, MCL 769.8. It says the maximum of every sentence is set by law and shall be stated at sentencing. So whatever the guidelines say about the minimum, the maximum is always going to be the maximum set by law, which creates an enormous amount of indeterminacy in your system. Fast forward 1972, the Tanner case came down where your Supreme Court basically said that indeterminacy means that the minimum can't eat up the maximum. You can't set a minimum that's just up to the borderline of the maximum because that's not an indeterminate sentence. And that change was later on adopted by the legislature as a rule in the books. 1979, there was a report of the Michigan Felony Sentencing Project that ultimately led to judicial guidelines being adopted in 1983. 1994, the Sentencing Commission was first created by the legislature, and in 1998, as Ms. Levine alluded, PA 317 was enacted, which was the legislative guidelines that still exist. And as I understand it, they were tie-barred or otherwise closely linked to the notion that there would be truth in sentencing for those minimum sentences. 2002, the commission was formally disbanded. It had withered away long before that. And then 2004, the National Center for State Courts did a study of sentencing in Michigan. And that was the last time that a concerted look was taken at sentencing until we came along. In 2013 and 14, the Council of State Governments was asked to do a sentencing and justice reinvestment project. And this is the third thing I wanted to mention to you all. One of the 7 policy options that we advanced was Michigan needs to monitor changes to the state's sentencing practices along with their impact, and it should establish a body and standards to independently and collaboratively monitor sentencing and system performance. The extensive analysis that my research colleagues did of your system is well worth taking a look back, and I will share this link with you. I really encourage people that are interested in Michigan sentencing to look at all the things that we observed through data analysis about the way your system works, and think about the fact that analysis serves as an example of the kind of thing that you should be coming to expect, that a sentencing commission should be able to do that sort of analysis of what's happening in your system at a very nuanced level, as we were able to do. So as I say, I'll send the link to those documents to the clerk, and I would encourage you to look at those. For all those reasons, I think, in my opinion, and I'm a big fan of the existence of sentencing commissions, of interdisciplinary collaborative bodies that are using data analysis to understand what's happening at this most important juncture in the criminal justice process, the point at which the judicial branch is convicting someone and giving them a sentence and handing them over to the executive branch to carry out that sentence. It is just a fundamental piece of what happens, and a deep understanding, transparency about how that works is vitally important. That's all my testimony. I appreciate, again, the opportunity to be with you.
Thank you. And now for member questions, Representative Breen.
Thank you, Madam Chair. I support the creation of this. I think it's important to note Michigan sentences are almost double that of the national average. We need to look at why. We need to look at recidivism rates. We do have treatment courts, and as Representative Filler put out, other successful programs, but we need to determine what it is about Michigan that leads to these longer sentences and figure out why they are or are not appropriate. We have racial disparities to consider. There's an economic argument, of course. It's like 34 to 48 grand a year, not including medical, to incarcerate someone. I am a lawyer. I do not have a criminal justice background, but I know there's going to be questions about truth in sentencing. And I'm wondering if somebody here can explain how and why this does or does not conflict with the truth in sentencing provisions that we currently have in law.
I can take that. Truth in sentencing was tie-barred to the original sentencing guidelines back in the 90s. But what truth in sentencing does is eliminate what used to be called good time and subsequently renamed disciplinary credits, but it's credit for good behavior. Other jurisdictions also have, in addition or instead of time off for good behavior, earned credits that award time off from the minimum sentence for program participation or work or other sorts of positive activities in prison. So the notion of truth in sentencing is you get a minimum sentence, whatever judge gives you after referring to the guidelines. But then there's no administratively taken time off that minimum sentence. You serve every day of that minimum under our current truth in sentencing scheme. And that's the result of separate legislation, and it wasn't contemplated it's not an inherently necessary part of looking at sentencing guidelines, other than keeping in mind that whatever minimum the judge picks, that's going to be served. It's not going to be reduced. So there was a time when good time was very generous, when judges could give very long sentences that looked very tough, knowing that the prisoner had control over how much of that he or she would actually serve, because the longer they serve, the more time off that minimum they'd get. That doesn't happen anymore. And the latest version of the bill explicitly takes consideration of truth in sentencing out of the Commission's realm. A lot of people support restoring good time credits for a whole variety of reasons, including internal management of the prisons, as well as having some sort of positive rewards. But it's a separate issue, and people can pursue that or not, but it's not an inherent part of sentencing guidelines.
So I just want to make sure I understand this correctly. The Commission will essentially help set the standards, and truth in sentencing is to make sure that those standards are met.
So I just want to be very clear, Representative. The substitute will be very explicit, and this will not touch the truth in sentencing component of this. So
okay.
The Commission is not going to talk about good time credits. It's not going to give recommendations on any of that stuff. It's sort of left that aside in the final version of the bill. So we have explicit language in the substitute that will clearly outline that.
Thank you.
Representative Arbit was next, but it looks like he may have stepped out. Representative Harris.
Thank you, Madam Chair. So with this commission, who is anticipated to staff it at this time?
Once the commission is established, we are gonna, the second part of this is looking at getting funding to make sure that we have experts that will be working alongside the commission to get this done.
So no one's been selected as chair at this time?
No, there's no commission right now.
Okay.
Representative Begol?
Thank you, Madam Chair. I noticed the bill on page 5 talks about working with the State Court Administrator's Office to collect, analyze, and compile certain data regarding caseloads and docket flow of trial and appellate courts. My question is there a reason why the State Court Administrator is not capable of performing that task without assistance of this new bureaucracy? It just seems to me there's a lot of effort being duplicated.
Is your question along the lines of what's being done here? Because you're suggesting it's already being done?
Yeah, I see a lot of that throughout the bill, but why the State Court Administrator's Office in particular would need the assistance of the commission? I could couple that with the appellate courts often review some of these sentences too, to be sure that the trial courts are following and doing what they're supposed to be doing. So I'm just wondering how about the duplication of that effort as well.
Yeah, in my mind, the idea here is to help this commission understand what's going on and give them the information they need.
And Representative Begol, this would, again, it would centralize. There's a lot of components when we look at sentencing guidelines, right? It's if you sort of keep it in a fragmented fashion, it becomes difficult, I think, to provide comprehensive recommendations for the legislature to then act. So this would allow the commission, given the breadth of the experts in what fields and areas that they come from, to be able to look at this data in one centralized way. Whereas if you're sort of looking at it fragmented, to your point, this court looks at it this way, and other groups look at it in other ways. This would just allow the commission to be able to look over this and then give recommendations in a centralized way rather than it being all over the place.
If I can follow up on that for 1 second, you'll also see that there's a provision that addresses cooperation with the MDOC, which also has its own research division. The courts collect data for their own purposes on how the trial courts are operating, how they're processing their caseloads. The DOC does an enormous amount of research on the corrections population. The purpose, I think, of these two provisions is simply for the commission to be able to connect with those two entities, utilize the data that they collect for their own purposes, and connect it to sentencing guidelines to see what the impact of the guidelines specifically is on DOC populations and trial level court operations. So it's not duplicating those efforts. It's, as the representative indicated, it's simply trying to
streamline it,
incorporate, collect all the data that's relevant to the operation of the guidelines themselves.
Representative Filler.
Thanks, Chair. Just the way I read this bill is, and the way I hear this testimony, I feel like there's a belief that sentences are too high in the state of Michigan from pretty much everybody involved in the drafting and support of this bill. And also when I read some of the things that go into this, a lot of discussion about diversion instead of prison, so jail instead of prison. So I guess my question would be, which prison sentences are too high? Is it CSC? Is it assault and battery? Is it human trafficking? I mean, which ones are too high?
To speak to the first point first, I think
because, and I'm sorry, Rep. I left an important part of it. If the purpose is to lower sentences, I mean, why don't you just put the bill forward to lower sentences in the state of Michigan?
Did you want to?
Go ahead.
Okay. Well, no. The purpose of the bill is to set the commission up. I don't know, personally. I mean, I'm a representative in the legislature.
You don't believe prison sentences are too high in the state of Michigan?
I'm saying that I don't have the expertise to make an informed opinion on that matter. So What I'm saying is, I do think we have to do something personally. You know, my political inclination is to say we probably might have to reassess some of our prison sentences. But I'm not in a place where I can say that and introduce legislation without leaning on the experts. For all we know, the experts can come back to the commission and say, hey, we actually need to increase sentence times. I'm not sure, because I'm not going to serve on that commission. This is simply to allow them to lean on the experts. It allows them to lean on folks that are directly involved in sentencing to be able to give us an analysis of, hey, does this make sense? And again, it's been 30 years. Just to give you, I'm going to go back to the two examples that I brought up. The way we look at drug crimes, right? We see a lot of diversion and things of that nature to sort of reduce or reassess some of those examples. A lot has changed since the 90s from today around drug crimes. Another example is...
I think we both would argue that probably, I guess, if there was a marijuana I mean, it's not even applicable anymore, right? But that strikes me. You could drop that bill tomorrow, and I'd probably sign off on it because marijuana is legal in the state of Michigan. I just don't see a need for a whole commission on something that you and I probably...
No, you're fine. I mean, the reality is there's so much to sort of look at. Another example is domestic violence, right? We, I think, maybe in the 90s, maybe have underestimated the level of impact and this severity of domestic violence disputes and issues, and perhaps that needs to be reassessed. I'm just here to say that I'm not sure what that reassessment would look like. I think we have less than 20 attorneys in the Michigan legislature, and even less if you look at the number who actually do and work in criminal justice. I know the representative from Novi made it clear that she's not a criminal attorney, right, criminal defense attorney, but she is an attorney. Now, does that mean that she has the expertise to sort of bring up all the ideas? I'm not sure, right? The commission will. If you look at the composition, who's going to be there, the experts that will be at the table to help look at the research, to look at the data, and it would simply say, based on our findings, this is what we think the legislature could do, but it certainly doesn't impose that we have to enact any of the recommendations that they bring up. And to your point, like I said, there could be a situation where they come back and say, hey, representatives, senators, you guys probably look at increasing sentences on some of these points or things of that nature. I just don't know. And, in the era of ChatGPT and sort of the AI component.
Ayash, I'm sorry to interrupt you, but we do have a couple more questions.
I
and
apologize.
We have a hard stop at 10:15.
I apologize.
Please continue your conversation offline. Representative Devendorf.
Okay, I just wanted to close that out by reminding us all that all commissions exist for the purpose of doing further research, consolidating all of the experts, making sure that we're using best practices, making sure we're not reinventing the wheel, making sure that we're not overlapping efforts. This commission exists for the same reason that we create just about every other commission. It needs to be created because there is a whole world of work right now that is being done on criminal justice reform and on prison reform, and it is incredible work. It is going to be very positive. It's going to bring us into the modern age, and it is absolutely necessary in order for us to continue to do criminal justice in a humane way. So we are bringing all of these folks together in order to make sure that we are not duplicating efforts, to make sure that we are bringing in the folks who have the best practices, because we are right now working in silos out of sheer enthusiasm and intent to make sure that we do this. So we need to do it the right way. The same reason we would create, and we do create, and that we have so many other commissions. That's it.
Representative Sterniglu, if you can be really quick.
Thank you. I just want to say I actually am a former defense attorney. I'm also a former victims advocate, and I served on the county board with Chair Hope. And all of those are different perspectives. And I wholeheartedly support your effort here, not because I think we need lower sentences on all crimes, but I think on some crimes we need higher sentences, and on some crimes we need lower sentences. And I think that we need a group of all of those stakeholders, including groups like sheriffs and prosecutors, so they can all look at that together, see what works, what's needed, how do we go from here. I think it's a misconception that this is a way to just lower all sentences. On the county board, I chaired the Law and Courts Committee, and one of our issues was jail overcrowding. So we need to make sure we have the right people in jail, that that's going to serve a purpose, and not the wrong people. And a lot of that goes along with the sentencing guidelines. So I just wanted to kind of put that out there, and thank you, for your work on this, because this is a way to make us all safer as a state, and just and also sometimes funding becomes an issue. And so that's something to look at as well. And I think that will also address
Rob.
that. Thank you.
Thank
Sorry.
you. We do have cards for the minutes that will be recorded, and I thank you for your testimony. Thank you. With no further business, we are adjourned.